Hello and welcome to Lexpert TV. I'm Rilka Erlia, and joining me for this special ESG update and overview is Stephen Pike, a Toronto-based partner at Gowling WLG and co-leader of the firm's Canadian ESG Advisory Services practice. Stephen is the co-editor of ESG in the Boardroom, a guidebook for directors published by the American Bar Association. Welcome, Stephen, and thank you for joining us.
Thank you very much. It's a pleasure to be here. I'm a big fan of Lexpert TV. I've watched a number of episodes. I think it's really a great platform to engage with and to get really valuable content. So I'm delighted that I have an opportunity to talk with you today, and I hope that the viewers will enjoy our discussion.
You are very welcome. First off, what is ESG?
Well, ESG is not a precise legal term with a commonly accepted legal or dictionary definition. I call it a dynamic umbrella term, dynamic because it continues to evolve and develop, and an umbrella term because it sort of rests over a long list, essentially an infinite list of different factors, risks, and opportunities. And because it's developing, the number of risks and opportunities and issues keeps growing. So it's really on top and as an umbrella would be. So why does this matter? It's because businesses need to understand these ESG issues, risks, and opportunities, the risks and opportunities and issues that are impacting it, and that how it's impacting its stakeholders. So because ESG is dynamic, if a business only uses a fixed and static inventory of ESG risks and opportunities that was compiled, for example, like on a specific date or particular point in time, the business will only have a limited view and understanding of its ESG landscape and won't be able to optimize how it's going to respond to and manage those risks and opportunities. And because ESG is dynamic and continues to change, it can't be just at one point in time. It can't be a once a year issue for the board to look at. And very importantly, those ESG risks and opportunities for a business will be bespoke to the business. It's not one size and fits all. There may be commonalities within an industry or an industry sector, but essentially it's going to be bespoke and custom to that specific business.
Thank you. Can you provide a little more detail of what would fit under the ESG umbrella?
And again, it's going to be bespoke to a business, but sort of at the 25,000 foot level, let's go through ES and G. So environmental would include or could include climate change, net zero, scope 1, 2, and 3, greenhouse gas emissions, product packaging, logistics, biodiversity, global access to water for irrigation purposes, land use, climate litigation, and more. On the social side, it could include social justice issues, treatment of employees, truth and reconciliation, paying a living wage, equity, diversity, and inclusion, pay equity, security of personal information, forced labor and child labor and supply chains, employee mental health. I mean, you may recall at the beginning of the COVID-19 pandemic, CEO after CEO were telling us that the health and safety of our people is our number one priority. Well, that's the S in ESG. And then from a governance perspective, corporate purpose, gender representation in the boardroom and C-suite, tax minimization strategies, directors' duties, executive pay, risk management, anti-money laundering, cybersecurity, risk management, I think I said before, use of artificial intelligence, anti-corruption, whistleblower policies, ESG reporting, CEO succession, and the list goes on and on. The very broad terms, many of them have, various perspectives that we could go into in detail. We could take a whole Lexpert TV session just to look at specific ES and G issues, but almost everything that the corporation has or business has to deal with would fit under the umbrella.
And who are the stakeholders and how are they part of ESG?
Let me give you a pathway into the stakeholders. Underpinning ESG is a foundation of corporate purpose. In other words, the reason why the business exists. And as such, corporate purposes are generally articulated by the board and senior management and fits together with a concept called stakeholder capitalism. Stakeholder capitalism is essentially a focus on generating sustainable long-term value for the benefit of the stakeholders. So going back a couple of years, in 2019, in the US, the Business Roundtable published a statement on the purpose of a corporation. It's signed by 181 CEOs of America's biggest corporations. And they made a number of commitments to parties they called their stakeholders, delivering value to our customers, investing in our employees, supporting the communities in which we work, dealing fairly and ethically with suppliers, and generating long-term value for shareholders. So customers, employees, communities, suppliers, shareholders, all of them were seen as stakeholders. And as recently as this year, Larry Fink, the CEO of BlackRock, wrote his annual letter to CEOs and talked about stakeholder capitalism, which he said is capitalism, but it's driven by mutually beneficial relationships between the business and the employees, customers, suppliers, and communities that the business relies on to prosper. So we see where stakeholder capitalism came from. My definition of stakeholders would be, I would call it people, organizations, businesses, and other collective entities or groups who are impacted by the activities of a business or who impact the business through ownership or through another relationship, activity, or proximity. And so let me go down a level and say, well, who might those stakeholders be? And again, it's going to be bespoke to the corporation or the business or organization that we're talking about, but shareholders, employees, communities, we've heard that, unions, lenders, retirees, landlords, First Nations, different industry associations, business partners, NGOs, competitors. So it's a long list. And once you get down to that level in looking at stakeholder capitalism and looking at the stakeholders, I would suggest, and that's a who kind of question, like who are the stakeholders? I would offer a few more perspectives. I would say that there's a when, which is to integrate a time perspective. So going beyond, for example, next quarter's earnings and looking at the long term, because time is an issue in terms of stakeholder interest. We could also add a where or a global perspective, because so many ESG issues, be they environmental or social justice, have a global impact and go far beyond wherever a business has its offices or warehouses or manufacturing facilities. And then so adding to the who, when, and where, I would add a what question, a what perspective. So looking at what are the stakeholders' most material and important issues. So it's more a holistic review beyond the who and including the when, the where, and the what. And so I would say that when a business is looking at developing a program to discover and engage with stakeholders, I think it's got to ask two critical questions. The first is, what are the most material ESG risks and opportunities from the business? In other words, looking at it from the inside out, and then the business needs to identify and prioritize which issues are the most important to the business's stakeholders. So to go with the inside out view, we need the perspective of outside in from the stakeholders. And then you can map the answers to those questions on shareholder or a stakeholder materiality matrix. And that assists in prioritizing stakeholders and stakeholder issues. The one thing I mentioned is that in many circumstances, stakeholder interests and expectations exceed legal, regulatory, and statutory requirements. So it's more than just a pure compliance exercise. It requires deep thought and commitment to the process by the business.
Can you tell us what are the role and duties of directors regarding ESG?
It would go beyond just Canada, but you could rename ESG as GSE because of the importance of the role of governance in the ESG landscape. I would suggest that the work of the board is crucial to the success of businesses in addressing these ESG risks and opportunities. I mean, let's start with the duties of directors in the Canadian context. And directors have fiduciary duties to act honestly and in good faith in the best interests of the corporation, and as well have a duty of care to exercise the care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. So going back to the Supreme Court of Canada, BCE and debenture holders case, the duty of the directors is to the corporation and only to the corporation. So they have to act honestly and in good faith with a view to the best interests of the corporation, and they owe that duty to the corporation. However, in Canada, they do have the opportunity and the legal backup to take into account the interests of stakeholders. And that was what the Supreme Court of Canada said in the BCE debenture holders case, and that was codified in the 2019 amendments to the Canada Business Corporations Act. So unlike the United States, where the theory of shareholder primacy, in other words, the theory that the corporation exists primarily for the benefit of shareholders, that we've gone past that in Canada, and with the Supreme Court of Canada and with the amendments to the Canada Business Corporations Act, it's clear that directors can take into account the interest of stakeholders, but they don't owe a fiduciary duty to the stakeholders either individually or in groups or as a totality. They owe that duty to the corporation.
Can you also give an example of how are directors exercising their fiduciary duties in respect of ESG?
And the role of the board in exercising those fiduciary duties, part of the exercise of those duties will be in respect of ESG. And ESG engages at least two of the most critical and important responsibilities of the board: oversight of risk management and oversight of strategic planning. So what we're seeing is boards taking an incredibly important role in managing and overseeing ESG within the business. And from my perspective, some of the questions that relate to that are, again, which ESG risks and opportunities are most essential and mission critical to the business? Has management designed and implemented a stakeholder discovery and engagement program? Has the board implemented an ESG reporting and information system so that the board's informed on a timely basis of ESG issues, risks, and opportunities that require its attention? And then does the board monitor, discuss, and address ESG issues in its meetings on a regular basis? So I would say in conclusion, the board's duties definitely include ESG at the highest level within a business or the corporation. And what we're seeing more and more is those duties being questioned, I'll put it that way, by different stakeholders. So for example, in March, in the UK, registered environmental charity called Client Earth initiated a legal action against the directors of Shell, seeking to hold the directors personally liable for an alleged breach of their fiduciary duty under the UK Companies Act, namely a failure to adopt and implement a climate strategy for Shell that would align with the net zero goals of the Paris Accord. Client Earth claims it's the first ever case in the world seeking to hold company directors personally liable for failing to properly prepare for the energy transition. I think in my view, I would venture to say it won't be the last attempt to hold directors personally liable for climate and energy related impacts. So within the G, we're seeing a duty of oversight of ESG risks and opportunities, and definitely a lot of attention focused by stakeholders on the exercise of those duties.
Great. Can you provide an example of an S issue that has become much more critical for Canadian businesses?
Under the S, the scope of S issues facing Canadian businesses from truth and reconciliation, diversity, equity and inclusion, social justice issues, vaccine mandates, and other COVID-19 pandemic issues, to human rights abuses in supply chains. We could, again, do another Lexpert TV presentation just on those issues. But let's focus for a few minutes on the issue of forced labor and child labor in supply chains and how Canadian businesses need to focus on these issues now. And the reason now is because there have been a lot of developments and dynamic change both in Canada and the US, as well as in Europe. And I'll give you just a brief précis of that you'll see how Canadian businesses need to be adapting. So first of all, in Canada, Bill S-211, Canada's Fighting Against Forced Labor and Child Labor in Supply Chains Act, was passed by the Senate. It's now moved to the House of Commons and has had first reading there. This legislation, if it became law, would require annual mandatory reporting by Canadian businesses subject to the Act, as well as by federal government institutions and departments. Those reports would require disclosure of the steps taken by the business during the previous year to prevent and reduce the risk of forced labor and child labor in being used at any step of the production of goods in Canada or elsewhere, or in the production of goods imported into Canada by that entity. Interestingly, and tying back into our question on directors' duties, this law would require the report to be approved by the entity's board of directors. So it raises this issue right up to the board level and would engage the director's fiduciary duties. Bill S-211 would also amend Canada's Tariff Act to prohibit the importation of goods made with child labor. So we have Canadian legislation being looked at right now in the House of Commons, and there may be more. In December of 2021, the Prime Minister issued mandate letters to the members of his cabinet, and the mandate letter to the Minister of Labor was to have him lead the government's efforts to eradicate forced labor from Canadian supply chains through the introduction of legislation in Canada. And 3 other cabinet ministers were tasked with supporting the efforts of the Minister of Labor. The other issue in Canada is that in late 2021, the Canada Border Services Agency made its first and only publicized seizure of forced labor-made goods since the prohibition on imports of such goods came into effect on July 1, 2020. So if we're looking at the potential impact on Canadian businesses, not only could Canadian businesses soon have to begin preparing and posting annual reports on forced labor and child labor in supply chains, but they're going to have to map and understand what's happening in their supply chains to ensure that they're in compliance with Canada's Tariff Act and Customs Act. And earlier this year, in February of 2022, the EU adopted a proposal for a directive on mandatory corporate sustainability due diligence. This would require companies subject to the law to not only carry out mandatory due diligence, but also to be responsible for mitigating and in some cases remediating adverse human rights and environmental impacts that they or those in its value chain have caused. So even though many Canadian businesses may not be operating in the EU, they may be required to report and certify, for example, as a supplier to an EU company that would be subject to the Act. So Canadian companies need to be aware of what their customers' obligations are under the EU directive.
And what about the United States?
In the US, the primary tool to combat forced labor in supply chains is enforcement at the border. The US Tariff Act prohibits the importation of goods made, manufactured, or produced with forced labor. And to enforce this legislation, Customs and Border Protection in the US can issue what's called withhold release orders when it receives information that reasonably, but not conclusively, indicates the goods were produced with forced labor. So once the Commissioner of the Customs and Border Protection issues that withhold release order, the goods are detained at the border and the onus shifts to the importer to prove that the goods were not made with forced labor. And that can be a very difficult thing for importers to prove when goods may be made and may have gone through many countries on the way to the US, and they have to source all the way back to the production of raw materials to show that nowhere in the supply chain of forced labor goods, in whole or in part, in producing the goods. The other big change, which will happen next month, is that law was passed in December 2021 by the US government called the Uyghur Forced Labor Prevention Act. So that became law in December. And essentially under that act, by June 21, 2022, Customs and Border Protection in the US will apply a rebuttable presumption that goods, wares, articles, and merchandise mined, produced, or manufactured in whole and part in the Xinjiang Uyghur Autonomous Region are prohibited from importation in the US and are deemed to be forced labor goods. That means the importer then has to prove by clear and convincing evidence that the goods are not forced labor made goods, and they need to rebut that presumption. So there's a lot going on at the border, and for Canadian companies that are shipping into the US, there's certainly a lot of issues they need to be aware of, and goods can get held up at the border or even be banned from importation if they're not careful and are not following American law.
Great. Thank you for joining us today, Stephen.
Well, thank you very much for having me here today. I really enjoyed our conversation and this opportunity to talk about ESG at this stage of its dynamic change. Thank you very much.
And thank you for watching Lexpert TV.